It's Lisa from Been There, Got Out, and we are going live with a major TikTok superstar, Stephanie, who's a domestic violence lawyer in New York. So she's going to be on any second. I'm just checking, but I'm really, really excited that she agreed to do this. Let's see, let me see, where is she? This is her first Instagram Live. She's a Instagram Live virgin. Found out about her. Oh, there she is. Okay, Stephanie, so let me invite you. And okay, so she should be on any second. So there, it works. I'm always so relieved when it works. So thanks again for agreeing to come on.
Thank you.
And of course, let me shut the window. Someone just started a lawn thing outside. Sorry about that. I had closed almost all the windows and there it went. Okay, so anyway, today we're going to talk about the myths and realities of family court, among other things. And before we get started, you want to just introduce yourself and give a little bit of background, especially why you chose this field of law.
Of course. So, hi everyone. My name is Stephanie. I am a domestic violence attorney. I practice in New York State. So I specialize in domestic violence, mostly in family court, and in New York State, divorces are in Supreme Court, which is separate, and also some criminal work as well. The why I chose this is I feel like it's a deep secret, even though I tell people all the time it's absolutely not a secret. I really didn't. It was never my plan in law school to do family law work. My focus in law school was criminal defense and gender and sexuality, and I really wanted to be in a courtroom, and I wanted to help people. Those were kind of my two priorities, and so those were the two paths that I followed. But when you are a young lawyer and you're trying to break into the nonprofit field, it's very difficult to get. I mean, I'm sure it's difficult for anyone in the legal field to get their dream job right out of law school. So I was kind of taking what I could get. I ended up at my first nonprofit, and they stuck me in the family law department. Like, I had actually initially applied for the disability program. They put me in family law. I started out doing just divorces, which I hated because I didn't get to go to court a lot. I found them kind of boring, and I noticed that the family court people were in court constantly and kind of hated it. I don't think a lot of them wanted to be litigators, and so I said, give me that position. That's what I want to do. And I ended up in family court, and I realized that family law, especially DV family law, is really the perfect place for someone who wants to litigate and who wants to fight for people. And no one in law school ever told me, if you want to represent marginalized communities, domestic violence victims are one of them. That was never a message that I heard. But I got in there and very quickly realized this is perfect. This is exactly what I want to do. And here I am, years later.
Yeah. Now, with law school, like, how much do you learn about domestic violence? There's a woman that I spoke to a couple of years ago. I think her name was Margaret Drew, and she teaches at the University of Massachusetts Law School. And she was saying that she wanted more information on coercive control to teach her law students, since they're the ones starting out and there were no classes on it. So how did you get focused on, like, where did you learn about domestic violence in terms of your legal background?
Yeah, not in law school. I mean, in law school, the required courses are debate. So it's civil law, it's criminal law, it's property. You're not, if you want to learn other fields, you have to take the initiative to do that. And so if there are domestic violence courses, certainly you could sign up for those, but it's not something most people are taught. For me, it was, the New York State Bar and the American Bar Association have a lot of training specific to domestic violence. I did a lot of those. There are also a lot of trauma professionals who are not lawyers, but are therapists, psychologists, social workers, etc., who do trainings for the legal community. I did a lot of those. So the answer is you really have to take the initiative to go out and find them, because it's not something you get in law school, and it's not something that lawyers early in their career get unless they go out and find them.
Yeah, and it's something that I know a lot of our clients find few and far between. And I remember you told me when we first talked that there's this website that I've used before when writing writing articles, but it's called womenslaw.org, and that's a good place to find a domestic violence attorney, right?
It is. You can go in there and you can look for, they have a places that help tab, and you can go into their legal assistance program page. You can search for your state, you can search for your county, and it'll show you DV specific legal organizations in your area, which is a great resource.
Great. Yeah. And is it lawyers as well as possible nonprofits and legal aid?
So most of them are nonprofits. There are very, very, very few law firms that only do work or mostly specialize in DV work, because for many, the nature of DV is isolation from finances, and law firms can't afford to run on clientele who don't have a lot of money. So it does end up mostly being nonprofits.
Yeah, well, that makes sense. Okay, so now let's start talking about some of those myths and realities. And I love that you're a fellow New Yorker, because we often say to our clients, we're going to have to give you the harsh New York reality check on what you think and then what we know. And you're a lawyer, so you're right in the trenches.
I am.
So one of the things you saw in my post this morning is a lot of people think that judges don't take abuse seriously. Is that true, or what have you found in your experience?
I do think for a large percentage of that is true. And I think there are a plethora of reasons. The main reason I don't think is because they don't care. I don't think it's because they're biased. Those are other reasons. I really think the main reason is because they're not trained in domestic violence. Very few states require DV training for judges, even family court judges who directly deal with domestic violence every day. And so the biggest issue, they don't have the training or the education to recognize these cases when they come through their courtroom.
Yeah, I mean, and we're going to get into like how they can become educated better.
Yeah.
So, have you ever heard of the term compassion fatigue?
Absolutely.
Do you think that has to do with it? Do you think it's that they see this all the time, that they just, or that they just get so like, all right, you know, I can't, like, I'm not as affected?
I don't know. I think a lot of, I think it varies by judge, because there are a lot of judges that go to the bench because they feel I'm unbiased. I can separate emotions from them. And so I can hear this because I don't let these things affect me. There are other judges. There are certainly judges who take the bench who think I care about DV, and so I should have this position. I certainly know judges like that. I don't know that it's compassion fatigue. I think that tends to affect professionals in my field more so, the people who are working directly with victims every day. Because the reality is, a judge, the parties come to their courtroom and then they leave, and the judge goes home at the end of the day, and they don't necessarily, I mean, it's not my place to speak for judges, but I don't think they carry home with them those cases in the way that the lawyers who still have to go to work the next day and work with that client do. So I'm not so sure that it's compassion fatigue.
Yeah. Okay. That's interesting. All right. Now, what about, people often say that no one really listens to women, and that, that men have a better chance in court. What have you noticed with that?
There are so many studies. I can speak to my personal experience, but I can also speak to the data that is out there. That is, women who claim DV in family court are very frequently not believed. People in general who claim domestic violence in family court are more likely to lose custody of their children to their abuser. And that goes back to judges not understanding DV, and also judges thinking that DV doesn't have a place in their courtroom. And so unfortunately, it partially is victims not being believed, which is a huge problem that we have in this country, and I'm sure in other countries. And, another part of it is judges think it doesn't belong there. And so they see it as like petty or trying to ruin the other parent's relationship with their children if you try to discuss DV issues in family court.
Yeah, I know that's something we also tell our clients a lot, like, let's not talk about abuse unless you're dealing with a restraining order. Let's focus on someone's patterns of behavior over time in different areas and really hone in on how it affects your child.
Yes.
Hopefully you'll get further.
Children lead with what the children experienced, what the children saw, as opposed to other DV that they maybe did not witness.
Yeah, I know. And it's really hard. I'm sure it's really hard for your clients as well. They're like, but this is so significant. And what's happened to me, they're going to do it to the child if they haven't already done it. And how can we go in there and argue a custody case without talking about the abuse towards me? And how do you deal with that?
It's incredibly difficult. I mean, a lot of our clients, you know, we have to weigh the pros and cons of filing any kind of claim. I will say, if you are also requesting an order of protection in family court, it can certainly help your custody case if there's a finding in that case before there's been a custody hearing, because now you have a full finding of domestic violence. But when it comes to just a custody case, a lot of the difficult conversations we have to have with clients is, this is what the judge wants to hear. I know this situation is the most important thing to you, and it's what you want everyone to hear. And I empathize with that, and I absolutely think this is important. But I need to be realistic with you. My job as an attorney is to be as honest with you as I can and to help you put on the best case you can in court. The reality is, judges don't care about what happened. Not all judges. I cannot make a blanket statement, but many judges don't care about what happened behind closed doors when the children were not present. And so it has to be this really solid balance of empathizing with them for what they went through, and also helping them realize that that incident is not what's going to help them win their case.
Yeah, I know. So I don't know if I told you this, Stephanie, when we talked earlier, but so my background is as an English teacher, and I loved to teach persuasive writing, and we often now transform it into the art of persuasive speaking, especially when you're dealing with a judge in a courtroom and custody evaluators. And so we talk about 3 elements, but it sounds like what you're talking about is called ethos, and that's the etiquette of the court. We sometimes refer to it as the decorum, and knowing exactly what you said, like knowing how you're expected to behave, knowing what the court wants to hear, and operating within that.
Absolutely. And you know, people don't love lawyers. A lot of commentary about not wanting to have to work with lawyers, but what I tell people about family court is the reality is these cases vary so much by what judge you're in front of, and the only person who knows what that judge wants to hear is the attorneys that are in front of them every day. And so while you may not like lawyers, you may not want a lawyer, you could easily go into a courtroom and screw up and not even realize it, but a lawyer is going to tell you what this person doesn't want to hear, and what's going to make for the best case, and what's going to totally derail your case.
Yeah, definitely. Okay, what about false allegations? How common is that? Is that, I mean, well, I already know, but let's hear about your experience with that. Is that something that happens all the time?
They are far less common than people think they are. There are a lot more solid statistics when it comes to false allegations of sexual assault than there are of domestic violence. If we're talking sexual assault, it's less than 1% of cases are false allegations. If we're talking, there are really only state-specific numbers that I've ever seen. I've never seen nationwide numbers, but they're still small. Usually less than 10% of cases are false allegations.
Really?
From the numbers that I've seen, there are states that report, you know, there's some states that report 16 or 17%. I usually see around 10. But the false allegations that we see in family court are almost always abusers making false allegations, get on an even playing field with the victim. So a lot of what we see is victim parent comes to family court, makes an allegation of DV, whether that be by filing a family offense petition or filing a custody petition. And abuser thinks, okay, well, now they have the upper hand, so I need to also file a defense petition, so we're on even playing field. And it's one, to influence the judge, so that you go into a courtroom and a judge thinks, okay, both of you commit DV. And it's two, it's a settlement tactic, because frequently what will then happen at the end of that case, as the judge is pushing parties to settle instead of going to trial, is an opposing attorney representing an abuser will say, well, you both filed these, so let's both agree to drop them, or let's both agree to mutual orders of protection. And it's a settlement tool. It's, you both did these things, you both deserve the same outcome, when in reality a victim doesn't deserve to have an order of protection against them. So that's the most common case of false allegations that we see in family court.
Yeah, and you just made me think of something different, but in terms of one person says one thing, another says another, and then the court says, why don't we agree to go down? And I feel like the victim loses. Like, for example, in my own case, where there's legal fees or some other interest awarded, and I go in and I'm like, okay, I'm going to get at least this amount, and the judge says, let's just settle for this so that you can get paid sooner. And I had to argue, like, no. And when there's already something in place for damages or restitution, and then there's a negotiation, it's basically punishing a victim and emboldening an abuser, because it's saying, even though you broke the order, even though you've been found in contempt, now we're going to negotiate down. So it means you can get away with it, and you're rewarded for getting away with it.
It's so often treating the abuser, they have the same level of credibility as the victim, and as if they deserve just as much compromise as the victim does. We had a case recently, and it was all numbers. It was a child support case where the abuser has been concealing a lot of their financial information.
Surprise.
Putting businesses in other people's names. We've heard it before. And so they came in to court offering a certain number for monthly child support. Our client, who knows how much this person makes because they were in a relationship for 10 years, came in with their number. And the judge, not understanding the complexities, just said, okay, so pick the number in the middle and settle this case. And it's like, for a DV victim who may have been isolated from finances, who may have not been allowed to leave the house to go to work, who doesn't have money to support their children, that may seem like a simple compromise to a judge who has a steady salary, but to someone who doesn't, that's a lot of money. And that's the difference between being able to take their kids out to dinner once a month.
Yeah, definitely. Okay, what about the idea of, I will have my day in court? Like, I can't wait to get before the judge, and I'm going to tell that person my whole story, and then justice will be rendered.
Mm-hmm. That's the number one myth. The biggest court myth is that if you are a DV victim, your claims of DV will be heard right away. If you are a DV victim, you will get to call the shots for what happens in your case. If you are a DV victim, you're going to get custody no matter what. And none of those things are true.
And validation also, right?
Absolutely. And I was thinking about this morning, because when we first talked, we didn't even discuss this aspect of it, which is the procedural aspect, which is judges actually cannot treat any claims as true before a trial. Because, for so many reasons, when you testify, you have to swear under oath that what you're saying is true. You have to have the ability to be cross-examined on everything you say. And when you admit evidence, it has to go through the process of admission and go over all these hurdles before it's admitted into evidence. And if we did that at every single court appearance, every court appearance would be a trial. And so judges cannot take anything as true as evidence in pretrial appearances. So you can make claims of DV for the purpose of getting a temporary order, but they cannot make any final rulings based on allegations alone.
You know, what you just said, I think we have a client just yesterday who was devastated in a pretrial appearance where there was some talking with different people that are involved with the case. And she was like, I know the judge believed him. He said all these false things. I feel like I can't get out of bed now. And I was just like, okay, I'm not sure. I mean, just because the judge didn't sympathize with you doesn't mean that they believed everything from the other side. And she had said that this was just some pre-thing, but they are going to go to an actual hearing. And so I was trying to calm her down to say, like, let's imagine that the judge doesn't really believe the accusations, and you have, a couple of weeks to get your case together and then go in with it. So I'm really glad that you just said that, because I think I'm going to have her watch this, and I think that she'll hopefully get out of bed and find some comfort in that.
And this is another, it speaks to the fact that lawyers know who they're in front of, and there are absolutely judges who I know, if I start yelling or I start shouting or I start throwing out allegations, they will get incredibly upset with me. And so I've been in courtrooms where the abuser, the opposing party, is making allegation after allegation after allegation, and my client is saying to me, why aren't you responding? Why aren't you taking my allegation? And it's because I know that it's going to piss off this judge. And I know the judge absolutely does not care what I'm saying and just wants to get this appearance over with. And in fact, is going to get upset with me and potentially hold a grudge against me if I delay this any further by throwing out allegations that they are not listening to actually.
Yeah, we've heard that before too, because that comes up all the time. Like, they're saying all this stuff and my lawyer's not doing anything and they're not defending me, and why isn't my lawyer? And another attorney that we interviewed said, because we know it's not worth it, and exactly what you said, it's just going to upset the judge because it's distracting and it's wasting time.
Yeah, and you also have to be really good at reading judges' facial expressions, especially now in this virtual world. I have so many clients who they're on the phone, they're not on video, and so I can see the judge's face and they can't. And later I'll say to them, look, I was looking at the judge's face as you were talking or as they were talking, and that's why I said don't respond, because I saw the face they were making.
Yeah, I'm really glad you mentioned that, because we also talk about paying attention to judges' body language. Can you give a couple of things that you noticed, like just obvious that somebody should, I mean, I have an idea, but I want to hear what yours are.
You know, I had a trial once that was a violation of an order of protection, and every single violation was the exact same act. And so what we wanted to show was that the same violation was occurring over and over, and we had like 200 pages of pictures of what this person was doing, but every picture was the same. And so strategically, I wanted to go through every single photo just to, you know, let it really sink in with the judge that this is how many times this happened. But the reality was I saw the judge rolling his eyes. I saw the judge kind of leaning down and getting tired. And so when you see a judge roll their eyes multiple times, you know they're not happy. And so I decided, let me admit a chunk of these at a time instead of one by one, because it's still in evidence. The judge still gets to look at all of these pictures when he goes back into chambers. But he's not pissed at me for taking 3 hours to do this instead of 1 hour to do this.
Yeah, that's a great one. Now, how can you tell that a judge is actually interested in what you're saying or what your client is saying? Like, what's a positive body language thing?
You know, I think it's good when this is a physical courtroom dynamic, but it's good when they're looking at your client. You know, the way a courtroom is set up, often the witness is right next to a judge. And so it's not natural for a judge to look at them because they have to turn their body, they may have to sit their chair, whatever it be. When they're looking at the client, that means they're listening. I also have judges who will kind of take over the role of an attorney and start asking their own questions, which is not their job, but they do have the authority to do it. And I don't mind when they do it, because it means that they want more information from the person and they want more of what happened. That kind of varies by judge. There are judges who will absolutely step in because they don't believe you and they want to catch you in a lie. But I frequently have judges who ask their own questions because they really want to hear more. And for me, that's a good sign.
Oh, that's so interesting. Yeah. And that makes me feel better with my own case. Like, I've had that. So that's great. Okay. All right. Here's another one to let us know if you think it's a myth or a reality. So during a divorce, I'm going to get full legal custody. So that means I'm going to be able to make decisions on medical, school, religion, because I'm the better parent at the get-go. How common is that?
Not common at all. Joint legal custody is the norm. It is incredibly hard. It's much easier to get full physical custody than it is to get full legal custody, because the law says that you as a parent have a right to make decisions about your child. You have a right to make decisions if you only see them once a week. You have a right to make decisions if you only see them in summers. You have the right to make decisions if you don't have a specific schedule and you see your kid only a handful of times a year. The law says both parents have equal decision-making rights. And so unless you've demonstrated an inability to make those decisions, like having made medical decisions or educational decisions that harmed a child, you know, I had a case where the abuser parent pulled the child out of school because they didn't like that their daughter had a girlfriend who went to that school. You know, that shows an inability to make the decisions that are best for your child. But absent like tangible examples like that, most people do not get sole legal custody. They get joint legal custody because both parents have decision-making rights.
Now, also, what about the tiebreaker? Because, well, actually, let me ask you about this. So, because this is like one of the top issues with our people is two parents, they have joint legal, so it's post-divorce, and one parent refuses to cooperate. So they end up being like, do we have to go to court? The co-parenting coordinator, we know, often extends the abuse, or at least for our people, because it just allows like more engagement, and the third party doesn't have decision making anyway. And so they're just always in court, like, how do I do? This person's impossible to work with. And then they're like, I'm going to just go for full legal. Like, what things would, because we believe that it's not just like one incident, unless it's extraordinary, but it's like a pattern of poor judgment.
Mm-hmm.
What do you think about that? Or what are some examples of what might move custody to one when it starts off as joint legal?
Yeah, absolutely. There are situations where there's a pattern that you can show, like consistently bringing the child to school late or pulling the child out of school early. That happens a lot. Not taking the child to medical appointments. I have a case right now where a child is about to have, unfortunately, a very serious procedure because the parent didn't take them to the doctor regularly. You know, if it's repeated things that affect school, medical, religion, etc., that makes for a much better case. Then you have the cases where it's like, well, and this is where it becomes important to have very, very specific custody schedules, because you have cases where they get weekends, but there's no pickup time. And so it's every Friday we're fighting for what time we're going to meet. And I have cases all the time that we bring to court that we say, look, it is impossible to compromise with this person because every Friday we're fighting over a pickup time if you refuse whatever time I suggest. Every Friday we're fighting for where we're going to do the exchange. And they say no to everything I suggest. And you can show texts upon texts upon texts of here are all the times that I tried to come to a compromise and it couldn't work. Unfortunately, the reality is a lot of judges say it's not my job to make that compromise for you. It's your job as parent. And that's where the lack of DV training really shines, because a judge with domestic violence training would know that you can't compromise with an abuser. It's not in their nature to compromise with someone that they think that they have control over or that they want to have control over. Those cases are much harder to prove. Even if you have piles of evidence showing that every time you've tried to decide a pickup time or a pickup location or, you know, who gets Christmas Eve and who gets Christmas Day, that there's total inability to compromise.
Yeah, I was thinking, like, I started thinking one thing and then I went into a different question and now I remember what I wanted to ask. So we have a friend who's an attorney, her name Joanna Boyd in Georgia, and she said that every time a divorce happens in Georgia, they write in a tiebreaker for legal. And I was like, ooh, I haven't heard of that up here in New York and Connecticut.
Yeah.
But how common is that, let's say, for a judge who is schooled in domestic violence to say this person will be the tiebreaker? Or is that something that's just much better attempted for in mediation? I think that's a rhetorical question.
It doesn't come up so often in front of judges as it does in settlement discussion. And so I believe what you're talking about is where it's joint legal with one person having final decision making. So when we have a client who wants sole legal and an abuser who wants joint legal, often a settlement compromise is, okay, these parties can have joint legal with the proposal that victim parent have final decision making if the parties cannot come to agreement. It's not always successful because the reality is that's just giving that person decision making in any situation.
Right.
I have seen, rarely, but I absolutely have seen cases that say like alternate decision making. So we'll take turns to final decision. I know, and keeping track of that is beyond me. I don't have the brain capacity to do that, but I have. I
know. I'm thinking like medical emergencies.
Right. Like, what do you count as? But I have seen orders that say they'll alternate decision making, or I've seen orders, and I don't think this is in the best interest of the child, but I've seen orders that say, well, this parent gets final decision making if it's a school related issue, but if it's a medical issue, it'll be a joint decision, or, you know, it'll specify certain areas, who makes these. For example, if you have a parent who is very religious and a parent who's not at all, okay, that person gets religious decision making. I think that muddies the water way too much, but it's a settlement tactic. I say all the time, people don't like to go to trial. It's very traumatizing. It's a lot of work. And so if you have to create this kind of convoluted compromise in order to not do that, I understand why people would go for that option.
Yeah, definitely. Okay, so now let me just check the time. Let's talk about something that I'm sure everyone also wants to hear about. What makes a domestic violence case more credible? That is like the big question. So essentially, like how can I prove abuse in court but not call it abuse? And we touched into it a little bit.
I mean, unfortunately, what judges want to see is they want to see photos, they want to hear from witnesses, and those are rare in domestic violence cases because it so often happens behind closed doors. But that's what they want. They want physical, tangible proof, or they want people who are not the parties, who have no stake in the outcome of the case, saying, well, I saw it happen, here's what happened. You know, I was talking about this with a friend recently, and this is less specific to family court where you don't have juries and more specific to criminal DV cases, but what we talk about in law school a lot, talk about in the DV realm a lot, is that what makes a credible case is a credible victim, which is problematic in so many ways, but there are many. This is what happens when you are putting on a case in front of a jury, a bunch of people who expect a DV victim to look a certain way, and what makes to them a credible case is a victim with, you know, just the right amount of emotion, but not too much emotion. A victim who doesn't seem cold and seems open to talking about what happened to them, which for so many victims, again, this is a traumatic experience, and they're not comfortable telling a room full of strangers what happened to them. And so what makes a credible case for a jury is someone who behaves the exact way that they want them to, and that's just completely unrealistic.
Unless someone's had acting lessons.
Right, unless they've been trained to behave a certain way on the stand.
Right.
You know, I think just documentation in general is helpful for family court, especially because trauma very much affects the memory. And so I always advise clients to calendars where they can keep track of what happened and what time, because judges like to hear dates. When you do a family offense petition, we try our best to organize chronologically by date so we can point to when this thing happened. It's more credible to judges.
Oh, Stephanie, your volume went off for a second. I don't know if you got a call. Let's try it again. Oh wait, now say something. Yes, okay.
It went away.
I know that always. I knew it. I was like, oh, okay, all right. So say it again.
Yeah. So I was saying, judges like to hear dates. They take an incident as more credible if you can not only say this thing happened, but here's when it happened. And trauma affects the memory. People often forget what happened to them and when it happened to them. So I always tell people to document, not so much because those calendars are going to be admissible in court, because they may or may not be, but if you're preparing for a trial and you can just look through a list of what happened and when it happened, it makes your testimony so much more credible because you have a lot more faith in what you're saying.
Yeah, and let me ask you a question about this. So we both know Brian Pockler, right? Yeah. The California attorney, and I've interviewed him before. And he had done a video about how when he organizes documentation, he starts with the most recent thing first. So instead of going, because in the past I thought, oh, we'll start at the beginning and then go to here. But he's saying, no, do the opposite. Why is that? So
we always do the opposite, and that is because a judge, time and time again, we heard judges say, well, the DV is not that recent, so you don't need an order of protection. You know, okay, they hit you, but that was last year, so it doesn't warrant an order of protection. So we always go reverse chronological order, most recent incident first, so they can see the most recent thing that happened, and they can see, yeah, there are incidents that we're going to claim that happened 2 years ago, but there are also things that happened last month. You're more likely to get granted an order if you can name recent incidents. And also the reality is, unfortunately, some judges don't read the entire petition. They're not going to read the whole thing, especially if it's very long. So put your recent things first, because that's what they're going to read first. And then you're more likely to
okay, that makes a lot of sense.
Stuff just happened.
Okay, now what about domestic violence being a factor in child support or in equitable distribution in divorce? I know in California, even though we're on the opposite coast, like DV makes a big impact, but what about in the other states or other parts of the world, you know?
So not so much in child support, because that money in theory is for the child, it's not for the parent. So even if you are paying to an abuser parent, they abused me is not grounds for decreasing the amount of support, because that money isn't for them, it's for your children. When it comes to maintenance, which you know is spousal support in New York, or equitable distribution, which is breaking up the assets in a divorce, varies. There are not many states that consider DV when it comes to those things. There are not many states that say, okay, if they abused you, they should pay alimony, or if they abused you, you shouldn't have to pay alimony to them. There are not many states that say, okay, because you endured abuse, you should get first pick of the assets in a divorce. And New York actually recently did pass a law that says you can consider domestic violence in equitable distribution. It's only just going into effect, so we don't really have examples of how it's working, how it's playing out, but we by all means now are in a position that we get to argue that, which we didn't before, which is amazing as a divorce lawyer, to be able to even mention that in a divorce when you're just talking about finances is amazing. That's something we could never do before. But the reality is few states allow you to mention domestic violence in either of those scenarios, and one of the toughest parts of my job is having to tell a DV victim that they have to pay alimony to their abuser, and that the person abused them is not grounds to say to a judge, don't make this person have to send a check to their abuser every month for the next 10 years.
Yeah, I can imagine. Did you hear about that case a few months ago in Canada? A woman was pro se and went in and managed to get like some huge amount of, I want to say 115,000, but I can't remember off the top of my head, to pay for enduring coercive control for like all the time that she was married. Did you hear about that?
I don't think I've heard about that exact case, but I do hear, I mean, Canada in general has a lot more progressive DV laws too. So I'm not.
I know. I think so too. Our Canadian friends and partners, like they don't think so, but I think they are more progressive than us as well. Yeah. So that's interesting though, and I feel like a lot of our female clients who have to pay alimony just to men have a really hard time.
It's, you know, I remember the first time I had a client who had paid maybe twice and called me and said, like, I can't do this anymore. I can't keep writing a check to this person every month. And it sucks because as attorneys, I don't really have a whole lot of power in that. I don't have a whole lot of say. The law says if you are the higher earning spouse and you were married for this amount of time, you have to pay them unless you come to some other settlement. And naturally, if an abuser knows they can get money out of their victim even after their divorce, they're going to go for it. So
oh yeah,
it's really hard having to tell people that they don't have a choice. Right.
And we know that money is the thing they care about, at least for everyone that we know. That's what they want, is money.
Easy way to keep contact with someone or keep control over someone after they've left you.
Absolutely. And, you know, our thing is legal abuse is to keep you in the system by motion after motion, and you keep coming back and there goes everything financially. Okay, what about, this is a big thing too with our people, and I'm sure yours as well, like how to properly handle reporting abuse during a custody battle. It seems like people often look at the timing and say, oh, now if you were married to this person for all these years and there was abuse, why wasn't it reported before? And now all of a sudden there's children involved and this person's a monster. Like, what have you found with that? And what do you think might be able to be better, again, adding to someone's credibility because of the timing?
I think one of the most beneficial things, and granted this depends upon you getting someone who really cares about their job and does their job well, but one of the most beneficial things for a parent in a custody case is having an attorney for the child or a law guardian, because they are, in theory, an unbiased party. They're not a friend or relative of either of these two parents. All they're doing is meeting with the child, talking to the child about what they've witnessed, what they've endured, and reporting it to the court. And judges take reports by so much more seriously than they do reports by either parent, because they're unbiased, because they have no stake in the outcome of this case. And so, especially if I have a client whose child is willing to talk about it or whose child is old enough to recall what happened, it is so beneficial to have an attorney for the child who can come into court and say the child told me these things happened, or the child told me they witnessed this, or they feel this way, or just this parent treats them this way. This parent is nicer to them than that parent. It makes my job so much easier when there's a third party attorney on my side.
Yeah, so now we call it in New York an attorney for the child, but is this the same, or we think it's similar to a guardian ad litem?
Yeah, so it's interesting because that term is so interchangeable. So our version of an attorney for the child is called a law guardian or a guardian ad litem in other states. But also in other states, they have law guardians for children who are not attorneys. They're advocates. They're trained advocates, but they're not lawyers. And so they act in a bit of a different role because they don't have the same rights as attorneys do in the courtroom. But all three of those terms are pretty much used synonymously.
Yeah, I know when in our case, we did have somebody appointed for my daughter who was a teenager at the time, and she was trained in DV, and our book is coming out later this year, and she's someone that I thanked in the acknowledgement because she was so excellent, and and I couldn't believe that the court appointed her, and we didn't have to pay for her. But she was phenomenal. Although I do hear a lot of complaints about guardian ad litems who people say don't have a high level of training and are biased, and there's all kinds of nonsense and don't understand coercive control. What's your experience with that? Do you find like a real range of experience with AFCs, attorneys for the children, or guardian ad litems?
I find very few that are trained in defense. It's not required for them because in theory they're not doing DV specific work, although that is a lot of family court. So I find very few AFCs trained in that. For me, I'd much rather have a judge trained in that than an AFC, although I want everyone to train in it. But as long as an AFC meets with the child and reports back what they said, I love to hear that. I have worked in parts of New York where I have had AFCs that never spoke to the child and showed up in court and were advocating for they never met and didn't know what their wishes were, didn't know how they felt about their parents. And that is like one of the most, and it's incredibly hard to get an AFC removed also. And so the most frustrating things for me is this person is perfectly suited to be an advocate for the child and tell the judge what no one else has the power to tell them. And when they're not bothering to do that job, it is so frustrating. And that's another difficult thing to tell a client. Like, I can't force this person to meet with your child. Even though that's their job, I have no authority to do that.
Yeah. And that's like the most heartbreaking part of what we deal with our clients, when they feel like their child doesn't have a voice and the guardian or attorney for the child doesn't listen or doesn't meet with them or doesn't understand, and they just don't know what to do. And we've had clients who have filed complaints. We met them after they filed the complaint. We were like, don't do that. Like, you don't want to upset the person that has so much power in your case, because they really do have the ear of the judge. Because we often say in our experience, and I don't know if it's the same in yours, that the judge doesn't have time to do a whole custody thing in court. It's more like the guardian or attorney for the child is appointed to save time and just report to the judge. Is that what you find as well?
Yeah, I mean, it is their job. They're the person's job. It is to report to the court. And so not only is the judge not going to listen to what the parents' reports are, but that's hearsay. If I as a parent go to court and I'm reporting what my child told to me, that's not admissible. And so that's another conversation I have to have with people is you don't get to tell the judge what your kid said because it's against the rules. So as difficult as it is, we have to put our trust in this person.
Yeah. Now you just made me think of something about the voice of the child in family court, which is like this big discussion all the time. How common is it for you to see children brought in to testify themselves, like with the judge?
It's not common. I very rarely see children testifying because, it used to be under New York state law that the job of the attorney for the child was not to report what the children were saying. The job of the attorney for the child was to listen to what the children said, and then for the attorney to decide what they felt was best and go to court and give their opinion as to what they felt was best. Then the law changed, and now their job is to report what the child says, whether they agree with it, whether they think it's been tainted. They, by all means, have the right to say, the child told me that they want to live with an abuser parent, but the way they said it made it seem like they were coached, or the way they said it, you know, I know they're only saying that because abuser parent just bought a big brand new house with a pool and a trampoline, and they have the right to say that. But now their job is tell the court what the child said to them, which I think is so much better, because then it's up to the judge, the decision maker, to hear the child's reports. But that used to not be the case.
That's interesting. So it's almost like the judge can form his or her own conclusions and not just accept the conclusions that were already made by the attorney for the child or guardian ad litem.
I mean, they absolutely do still give heavy weight to the attorney for the child's wishes and what they think is best. And that's why I try very hard to make sure I have a good relationship with all of my AFCs, because their opinion still has a lot of weight on the judge. But yeah, the judge is the ultimate decision maker, no one else.
Yeah. Now, what you just said about your relationship with the AFC, like how, and again, everybody, that's attorney for the child, guardian ad litem. How important? So say you know the attorney for the child. How impactful is that for your client? Like, and also, do judges? I know in our case, the judge just assigned somebody. I don't know where she came from. She was awesome, but like I got lucky. I know I got really lucky. But I know a lot of our people worry that if a guardian ad litem is friends with the other side's attorney, that means that it's going to go in that person's favor. So what do you think about that?
That is a very common belief. I've seen it happen where they're friends with the other attorney and that works in that side's favor, but not frequently. For me, I can have a great relationship with the AFC. I can know them outside of the courtroom. I can know their agency. You know, in parts of New York, it's a designated agency that provides AFC, so you're kind of getting the same handful of people, and you do get them. But for me, I don't have to be buddy-buddy with them. We just have to have created an open line of communication. What's important to me is knowing that I can call them and say, hey, the child is reporting this to my client. Do you mind giving them a call? As long as I have like a courteous and communicative relationship with them, we don't have to be friends for them to work in my favor. We don't have to be friendly for their job and my job to work together to do what's best for the kid.
Okay. All right. That's good. All right. I'm just checking the time. I'm like, I feel, of course I knew we were going to run out of time. Actually, you know what? I'm going to like wind up this, but I still have other questions I want to ask you. So Stephanie, would you come back another time to finish doing this interview? Because I know you have court in a little while, and people like painting my neighbor's house. I hope it hasn't been made too much noise in the background. I thought I had closed all the windows.
I haven't heard.
Okay. Okay, so why don't we wind up this and then continue it another time? But you want to tell people any last pointers? I know we're not going to talk about where you work, but let's say someone is looking for, can you just repeat? I know we said at the beginning, but different people come in and out. Like if someone's looking for a lawyer like you, specializing in domestic violence, which is like a unicorn, like how can they find someone like you?
Yeah.
Or you?
Yeah. An incredibly common commentary I get online, which is, I can't afford a lawyer, or lawyers like you don't exist everywhere. And that's not, neither of those things are true. But the general public is not informed of organizations and services like mine, so they don't know that they have access to them. So what I tell everyone is that it's a great website, it's witlaw.org, and do not let the name confuse you. Anyone of any gender can go on there and find services on there. They have a webpage called Places That Help, where you can access legal assistance, you can access DV advocates, you can find DV shelters on there. And all it is you go to that page, you select what you're looking for. So if you're looking for a lawyer, you would click legal assistance. And then it allows you to search by state and by county. So you can go to your state and you can go to your county and you can find DV organizations that specialize in DV law. And on that page, it gives you all their contact information, so their phone number, their website, their email address if they have one. And then it also says what they do. And under all of them, it says, nonprofit, which means you're not paying for their services, and it's pretty much exclusively nonprofits on there. And it says they do DV family law, they do DV disability, they do DV immigration. So I tell everyone, people message me all the time and ask, how do I find a lawyer like you? And I always direct them to that website.
That's excellent. Thank you so much. All right, someone's saying, what's the name of the site again? Say it one more time. womenslaw.org. Yeah. All right, Stephanie. So thank you so much. Good luck in court later, and we will continue this conversation again.
I'm looking forward to it. Thank you for having me.
All right. Talk soon.
Bye.
Bye.